This is the Wizard News. The Supreme Court on June 15, 2023, preserved the system that gives preference to Native American families in foster care and adoption proceedings of Native children, rejecting a broad attack from some Republican-led states and white families who argued it is based on race. The court left in place the 1978 Indian Child Welfare Act, which was enacted to address concerns that Native children were being separated from their families and placed in non-Native homes. Tribal leaders have backed the law as a means of preserving their families, traditions, and cultures, and had warned that a broad ruling against the tribes could have undermined their ability to govern themselves. The issues are complicated. Justice Amy Coney Barrett wrote for a 7-justice majority that included the court's 3 liberals and 4 of its 6 conservatives. But the bottom line is that we reject all of the petitioner's challenges to the statute. Justice Clarence Thomas and Samuel Alito dissented, each writing that Congress lacks the authority to interfere with foster care placements and adoptions, typically the province of the states. The decision, Alito wrote, this serves the rights and interests of these children. But Justice Neil Gorsuch, a Colorado native who has emerged as a champion of Native rights since joining the court in 2017, wrote in a separate opinion that the decision safeguards the ability of tribal members to raise their children free from interference by state authorities and other outside parties. The leaders of tribes involved in the case called the outcome a major victory for tribes and Native children. We hope this decision will lay to rest the political attacks aimed at diminishing tribal sovereignty and creating instability throughout Indian law that have persisted for too long, said a joint statement from Indian nations leaders. President Joe Biden, whose administration defended the law at the High Court, noted that he supported the law 45 years ago when he was a Democratic senator from Delaware. Congress passed the law in response to the rate at which Native American and Alaska Native children were taken from their homes by public and private agencies. The law requires states to notify tribes and seek placement with the child's extended family, members of the child's tribe, or other Native American families. 3 white families, the state of Texas, and a small number of other states claim the law is unconstitutional under the Equal Protection Clause because it was based on race. They also contended it puts the interests of tribes ahead of children and improperly allows the federal government too much power over adoptions and foster placements, areas that typically are under state control. At last fall's arguments, several conservative justices expressed concern about at least one aspect of the law that gives preference to Native parents, even if they are of a different tribe from the child they are seeking to adopt or foster. The Supreme Court dealt with that issue by determining that neither Texas nor the parents had legal standing to make that argument in this case. The plaintiffs can make those arguments in state court proceedings, the justices said. More than 3/4 of the 574 federally recognized tribes in the country and nearly 24 state attorneys general across the political spectrum had called on the High Court to uphold the law. Before the Indian Child Welfare Act was enacted, between 25% and 35% of Native American children were being taken from their homes and placed with adoptive families in foster care or in institutions. Most were placed with white families or in boarding schools in attempts to assimilate them. Source: Associated Press, June 15, 2023.